Good morning in Japan and good evening in the United States. I am Jason Murata, a partner at the firm of Axon, Veltrop, and Harkrider. Together with Todd Baker, I am a co-chair of the AIPLA IP Practice in Japan Committee. It is my pleasure to welcome you to the joint meeting of the Japan Patent Attorneys Association, AIPPI-Japan, and the IP Practice in Japan Committee. Unfortunately, we were unable to meet in person again at our traditional pre-meeting at the annual meeting a couple weeks ago. However, I am thrilled that we are able to continue the tradition of exchanging valuable legal information as well as camaraderie using this online platform. I would like to take a moment to thank the sponsors of the AIPLA IP Practice in Japan Committee. You may have seen their logos before the program started, but I would just like to recognize them briefly again. The law firms of Axon, Veltrop, and Harkrider, Finnegan Henderson, Dowling, WLG, Greenblum and Bernstein, Honigman, Kirkland and Ellis, Oblon, Osha, Bergman, Watanabe, and Burton, Prince Pines, Shook, Hardy, and Bacon, Smart and Bigger, and Studebaker and Brackett. If you see anybody from these firms, please take a moment to thank them for their support of this committee. Before we get started, I would also like to remind everybody about a few ground rules. The educational portion of today's program is being recorded. The networking session will not be recorded. To avoid distractions and stray noises, please keep your video and microphone muted during the presentations if you are not presenting. If you have any questions during the presentations, please enter them into the chat box. If the speakers are able to do so, they will pick up the questions in the chat box. With that, we have some opening remarks from each of the participating organizations. I would like to invite Patrick Coyne, President-elect of AIPLA, to offer some opening comments.
Jason, thank you very much. And good evening, everyone in the States, and good morning, everyone in Japan. It's great to see everybody again, and thank you for participating in this program. We're now 9 months into the pandemic, and we seem to have at least stabilized with this committee holding programs on a regular basis. And for that, I am very thankful. And we all look forward to a time, hopefully very soon, where we can all get together again. I don't know if anybody saw it today, but there was an announcement by one of the major pharma companies that a vaccine had cleared human trials and may be going into production. So hopefully sometime in the second or third quarters next year, we'll all be able to resume our regular activities and get together and see each other in person. But for tonight, thank you for participating, and it's great to see all of you. Thank you.
Thank you, Patrick. I would next like to invite Mr. Yoshihiro Shimizu, JPAA President, to offer his opening remarks.
Thank you, Mr. Jason. Good evening, everyone from US, and good morning, everyone from Japan. I am Yoshihiro Shimizu, the President of JPAA this year. I am delighted and honored to address opening remarks on behalf of JPAA. And please accept sincere gratitude for holding this wonderful event with us. Also, I'd like to extend our special thanks to AIPLA President Mr. Joseph Lee and all of the members of the IP Practice in Japan Committee. And also, our special thanks to AIPPI-Japan for co-organizing this trilateral virtual meeting. As you are aware, due to COVID-19, almost all the meetings over the world have been affected. Some were postponed or cancelled, and some were decided to be held online. AIPLA JPAA Tokyo meetings was one of them. However, even in this difficult situation, I'm delighted to be able to hold 2 days online meetings with AIPLA and AIPPI-Japan as a new attempt. Making it possible, we communicate and exchange information with each other more frequently. I believe this new attempt is a good challenge for us because this will provide with more flexibility for our long-term relationship between AIPLA and JPAA. Virtual meetings are borderless, free from cost of further trip and accommodation. Just a bit concern is time difference between us and karaoke in person. Again, I would like to appreciate the AIPLA's continuous contribution to all of our JPA members in this difficult situation. I'd like to conclude my opening address with wishing health and safety for you and your families and colleagues. And also hoping virtual meeting today to be fruitful. I look forward to seeing you in person again in the near future. Thank you.
Thank you very much, Mr. Shimizu. I would like to now invite Mr. Yuzuru Okabe, Vice President of AIPPI-Japan, to offer his opening remarks. Is Mr. Okabe on the line? Okay, well, perhaps we'll move forward then. So we will now begin the formal portion of our program. We are pleased to have Mr. Tomoaki Tachibana from JPAA present regarding his analysis of some recent Supreme Court decisions in the US and Japan.
Jason, can you hear me?
Yes, we can hear you.
Okay, thank you for your kind introduction. Good evening and good morning. Well, I'm not sure whether I can say see or meet in this Zoom meeting, but anyway, it's good to see you again for somebody, and it's nice to see you, nice to meet you for somebody else. Well, my presentation includes those 3 topics. Our first topic is comparison of recent Supreme Court decisions in US and Japan. There are more than 18 Supreme Court cases in recent 5 or 6 years related to IP in US and 7 cases related to IP in Japan. And the case in regard to IPR in US is becoming important since IPR is kind of new system, especially whether the IPR should be instituted or not, and whether those decisions is appealable or not is a big issue. And talking about decision of cases, of course, US court follows US Act and rules, and the Japanese court follows Japanese Act and rules. So it's difficult to compare simply. However, some US cases decisions are surprisingly in sight of similar cases in Japan. Here are the recent Supreme Court cases in US. Please note that copyright, trade secret, and unfair competition cases are not included. And here is the recent Supreme Court cases in Japan. As I mentioned, there are 7 cases in regard to IP in recent years in Japan. And most of them are related to patent infringement. The number of cases in Japan is less than US. However, please note that the IP Act in Japan amended last year. One of the big changes are provisions about amount of damages. In the amendment, lost profit and amount equivalent to royalty might increase. And another one is about evidence collection. In the amendment, new inspection system has started, so the evidence collection might be easy. It is said those changes may affect the number of litigation cases. However, those new rules have just started this year, so we should pay attention to the trend of litigations in Japan. Let's move to the next topic. Here are the Supreme Court cases regarding IPR cases in Japan. No, in US. As you know, whether the IPR should be instituted or not, and the decisions of instituted or not is appealable or not, were argued in many cases in PTAB, CFC, and also in Supreme Court. In Japan, Supreme Court case regarding trial for invalidation is not so often. And whether the trial should be instituted or not has not argued in recent years. According to Japanese Act and rules, once the request for trial was submitted properly by interested party, the trial is basically instituted. And also, there are no time bar restrictions for request for trial. So that's why in the Supreme Court, there are not so often discussed about the institution. Let me move to the next topic. Surprising cases. As I mentioned, there are different about Act or law in US and Japan. So even the similar case, the decisions can be different between US and Japan. However, some case decisions are completely different, and consider those differences is a good way to understand each country's system and its features. This case, Impression Product versus Lexmark International, is one of an example. Lexmark sold 2 types of cartridge, regular cartridge and return program cartridge. Return program cartridge has been sold as single-use, no resale restrictions. So the return cartridge program has sold by post-sale restrictions. Impression Products resold return program cartridge by exchanging some parts and rewriting IC chips. Lexmark sued Impression Product. Impression Product defended that the patent was exhausted. So the issues are, how does it affect post-sale restrictions? And also, what about international exhaustion? CFC said about the post-sale restriction that the patent does not become exhausted if the product was sold by breach of the post-sale restrictions. And also about the international exhaustion, that the patent does not become exhausted if the product was sold overseas. However, Supreme Court said about the post-sale restrictions, patent becomes exhausted even if the product was sold in breach of the post-sale restrictions. And also about international exhaustion, patent becomes exhausted even if the product was sold overseas. Those are corresponding cases in Japan. This case, in-cartridge case, is also in-cartridge case, but the defendant and the plaintiff are different from the US case. In this case, Supreme Court said the patent was exhausted when the patentee sold the product, I mean the original product. However, if the third party manufactured the recycled product by exchanging some parts of the original product, and the recycled product lacks identity with the original product, the third party's exploitation infringes the patent. So, the Supreme Court indicated that whether the third party manufactured a new product or not is the criteria. And another case, BBS, the Supreme Court says that this patent was exhausted when the patentee sold the product overseas. However, if there are post-sale restrictions among the patentee and the third party, and that third party sold the product by breach of the post-sale restrictions, that third party's exploitation infringes the patent. Also, if the product is sold by another third party who is not involved in the post-sale restrictions, and the post-sale restrictions are clearly shown on the product, the patentee can enforce based on the patent. So in this case, Supreme Court indicated that international exhaustion is affirmed. However, the post-sale restrictions are effective under certain conditions. Okay, let's move to the another case. Western Gecko versus Ion Graphical. In this case, Western Gecko owns a patent for a system used to survey the ocean floor. And Ion began selling a competing system that was built from components manufactured in the United States and shipped to companies abroad and assembled there into a system indistinguishable from Western Gecko's. And Western Gecko sued for patent infringement under section 271F1 and F2 and demanded damages based on 284. CFC said that the Western Gecko cannot demand damages for lost profit by Ion's foreign exploitation because such exploitation is outside the scope of the US patent. However, Supreme Court said that the focus of 284 in a case involving infringement under 271F2 is on the act of exporting component from the United States. So the conduct in this case that is relevant to the statutory focus clearly occurred in the United States. Therefore, Western Gecko can demand damages for lost profit by Ion's foreign exploitation. This is a corresponding case in Japan. However, please note, this is a district court case. In this case, the plaintiff owns a method patent, and the defendant manufactures the product in Japan, which is used for the method patent. And the defendant exports the product to the US, and it's not exploiting in Japan. In this case, it's obviously that the direct infringement is not established because the defendant exports the product and the patent is for method. And what about indirect infringement? Here's the related Patent Act provisions in Japan. In Article 2.3 says that the working of an invention in this act means the following act. And number 2, in the case of an invention of a process, the use thereof. And also, there is an article about indirect infringement. Article 1.1 says that the following act shall be deemed to constitute infringement of a patent right or an exclusive license. And number 5 says, where a patent has been granted for an invention of a process, act of producing, assigning, and importing or offering for assignment, and so on. In this case, the plaintiff said the defendant's exploitation should be understood to constitute indirect infringement based on Article 115. Because the defendant's product obviously used a patented method. It does not matter whether the method is exploited domestically or overseas. So the plaintiff said that the indirect infringement is independent from direct infringement. However, defendants said that even if the product uses the patented method, the method does not constitute indirect infringement since the method is exploited overseas. Indirect infringement cannot be established unless direct infringement is established. So the defendant said the indirect infringement depends on direct infringement. The court said the defendant's exploitation does not infringe the patent. The reasons are working in Article 2.3 should be comprehended only in Japan. Therefore, for a product which uses a patent but is only sold overseas, it should be understood that the patentee cannot enforce the exploitation based on the patent. If the patentee can enforce a product which is exploited only overseas, it should be said that the scope of the patent was wrongfully extended because the patentee does not have any profit in foreign market based on the patent in Japan. So please note, again, there are no Supreme Court cases in regard to this issue in Japan. However, Japanese system basically follows the territoriality principle. Okay, this is a summary of this presentation. The number of cases in the Supreme Court in Japan is not so many. However, we should observe the effect of IP Act amended in 2019 and started this year. And comparing and considering the cases in the US and Japan is useful to understand the features of each of the systems. That's all I have, and thank you for your kind attention.
Thank you, Tachibana-san. Are there any questions? Perhaps I could ask you a question. In terms of the last cases you were discussing about the method having to be practiced within Japan for there to be damages, increasingly in technologies like AI and 5G, IoT, methods of using technology have become much more important. Do you think that there will be any changes or any further consideration about this rule to accommodate new emerging technologies?
It's a difficult question. AI and the AI technologies may affect those decisions. Well, well, I think the personally, I think it may affect where our Japanese patent attorney uh, should be adjust and prepare for those changes, and also Japanese act and laws may revise or to include those technologies. I think it's personal opinion.
Thank you. Are there any other questions for Tachibana-san? Well, thank you very much for your very interesting presentation.
Thank you.
We'll now have Ms. Libby DeMarco from AIPLA present regarding means plus function claims. Libby?
Libby, you may want to uncheck presenter view.
Yeah, I think, is that better? Can you see my slides?
Yes.
Okay. Thank you for your patience. Hello, everyone. I wanted to say, well, please excuse my pronunciation, but I wanted to say Ohayo gozaimasu to everyone joining us from Japan. And of course, good evening to everyone who's joining us today from the US. Thank you very much, first of all, for the opportunity to present on the topic of means plus function claims under US patent law. I am an attorney at the law firm Wolf Greenfield & Sachs, based in Boston, Massachusetts. For today's presentation, I wanted to start with a little bit of background information about what a means plus function claim is and how to interpret it, as well as the scope, especially for anyone who's not familiar with means plus function claims. I also will discuss the practical significance of means plus function claims, especially during US patent litigation, and why these issues are sometimes contested. And I will finish with some practice tips that relate to drafting claims that are means plus function claims, as well as responding to an examiner during US prosecution. And I wanted to include a disclaimer because I do have some examples that these examples are really informational in nature and shouldn't be considered legal advice for a specific claim, but hopefully they will be informative. So in terms of background, what is a means plus function term under US law? What we are referring to when we say means plus function terms, it really is functional claim language that is describing an apparatus by what it does and how it functions, rather than what it actually is or its structure. A lot of these claims historically, especially a long time ago, 20 years ago, used the magic phrase means for, but they don't always use the word means or the term means for. So some examples would be means for reading program code, that's an easy one, but also distributed learning control module for receiving communications transmitted between the presenter and the audience member computer systems. That one might seem random, but that's actually a term that was construed and considered by the Federal Circuit and found to be a means plus function term. Another example would be mechanical control assembly configured to, and then a function that follows after the phrase configured to. The scope of means plus function terms is governed by statute in the US, and it falls under 35 USC section 112F. And before the AIA was enacted, that was section 112, paragraph 6. It was essentially identical before the AIA was enacted. There's nothing inherently wrong with means plus function terms either. They are expressly permitted by statute. The statute provides an element in a claim may be expressed as a means or step for performing a specified function without the recital of structure, material, or acts. And then the statute goes on to explain what the scope of any such term is by saying, such claim shall be construed to cover the corresponding structure, material, or acts described in the specification. And so what this means is that when you use a means plus function term, although you're describing the functionality, the claim does not cover literally every means for achieving that functionality. Instead, it's limited to the structure that's described in the specification or written description for the patent. And the result of that is also that a means plus function claim, or a section 112F claim, we sometimes call them, it's only valid if there is sufficient structure described in the specification. And if there isn't a sufficient structure described, then you can have your means plus function term and the claim as a whole found to be invalid for indefiniteness. So to interpret a term using section 112F, it's a two-step analysis. And the first step is whether the term is a means plus function term that should be subject to the requirements of 112F. If the answer to that is no, then you would continue with claim construction analysis to determine what the term means, but it's not limited to anything specifically described in the specification. But if the answer to that question is yes, then you look to see what the corresponding structure is as described in the specification, and so that you can know what the scope of that means plus function term or 112F term is. In a recent Federal Circuit decision, the CAFC clarified that although these inquiries are related, and especially the first inquiry does require you to look to the specification often, they are actually two separate and distinct questions. And so the CAFC cautioned courts and even examiners not to conflate the questions. So looking a little bit more closely at the first step, which is whether the claim term is in fact subject to 112F and considered a means plus function term. If a term uses the word means or says means for, it's usually pretty straightforward. The language means for will create a rebuttable presumption that section 112F does apply. Now that can be overcome, but it's more common that terms that say means for are interpreted as means plus function terms. If a term does not use the word means, there is also a rebuttable presumption that section 112F does not apply. But again, that doesn't necessarily mean that a term that does not use the word means can't be a means plus function term. And before 2015, it was fairly uncommon for terms that did not use the phrase means for to be considered means plus function terms. But in 2015, there was a decision from the Federal Circuit, and that's Williamson versus Citrix, where the CAFC lowered the standard for rebutting that presumption for terms that do not use means. And they eliminated the interpretation that it was a, quote, strong presumption, and explicitly said it is not a strong presumption, it's merely a rebuttable presumption, and that the relevant standard is really how a person of ordinary skill in the art would interpret the term and whether they would understand the term to have a definite structure or not. And so the CAFC clarified that this presumption will be overcome if the party challenging the presumption can show that the term does not recite a sufficiently definite structure or recites a function without the structure for performing that function. And so the test really focuses on when you look at the claim and specifically the term, is there sufficient structure for a person of skill in the art? You can have a claim that's reciting a function and it's very clearly functional language, but if there is nonetheless sufficient structure in the surrounding claim language, it will not be interpreted to be a means plus function claim. The first step of the 112F means plus function analysis is highly context specific. It typically requires examining the surrounding claim language, the specification, the prosecution history, dependent claims at times, and even extrinsic evidence, which can include expert testimony. In another recent decision from the Federal Circuit, which is Samsung Electronics America versus, I'm not going to say that right, Prisua Engineering, there was a term disputed that was digital processing unit. And the PTAB had found it to be a means plus function term, but the CAFC disagreed, looking at surrounding claim language that clearly demonstrated a sufficient structure, as well as expert testimony from one of the inventors that digital processing unit would have been understood to have a specific structure and therefore was not just functional language. This is, I've thought, an interesting depiction of the way that claims have changed over the years. And the blue line shows claims that use that traditional means or means for language, which was pretty high back in the 80s and has sort of steadily declined over recent years. In contrast, the green line shows claims that use language for ... something ending in ing. So for processing, for analyzing, for determining. And the red line shows claims that include language configured to or configured for. And both of those types of claims have been increasing at the same time as these means type claims have been decreasing. There's been a slight decrease of the green claims. And this data is a little bit old, but an interesting trend, I think. So sometimes in the US, you'll hear the phrase "nonce" or generic words. And these are words that in drafting claims, people, if they do not want them to be treated as means plus function terms, you will typically try to avoid these because they are often found to be just substitutes for the word means. They're generic words that really have no specific structure and it's just another way of saying means. So some examples are mechanism, module, device, unit, component, element, member, machine, words that you would just plug in to replace the word means. But on the other hand, if you were to take device, and it would be a very specific type of device, and one that was with a name and a specific structure described in the specification, then you might transform device to something that's not a nonce word. Processor is an interesting term for purposes of a claim. because it's somewhere in the middle. It's usually not subject to 112F and not found to trigger means plus function, but it can be if it's essentially a replacement for a generic processor for performing a very specific function that a person of skill in the art wouldn't understand a general purpose processor to be able to do. And so again, it can be very context specific. I included a citation here to a district court case, Kit Check Inc. versus Healthcare Logistics, which has a really interesting summary of when processor invokes means plus function treatment and when it doesn't. So the second step is determining the structure. And I won't spend too much time on this because again, it is context specific and I want to spend some time on practical tips. But if two specific points I wanted to make are that if there are multiple functions described in this term that has been determined to be a means plus function term, the specification has to disclose a structure that can perform all of the claimed functions in order for it to be sufficiently described and sufficiently definite. And if the structure can only perform some of the claimed functions, you'll have a validity problem. Separately, for software, when you have a means plus function term that revolves around software, the structure will typically be limited to the algorithm that's being carried out by a microprocessor. There's an exception here, which is similar to what I was referring to for the term processor, but very generic functions like processing, receiving, and storing that can be accomplished by any general purpose computer or processor. Those will not be limited to a specific algorithm because pretty much any processor can perform them. And so there's no need to disclose a specific algorithm to do those functions. And that's referred to as the CATS exception. So why does 112F and means plus function terms matter during US litigation? It typically arises as relevant in one of two ways. First, it can create an indefinite defense based on lack of sufficient structure. And here, if the term is considered a means plus function term, but there's not sufficient structure disclosed in the patent, then the term will be indefinite and therefore invalid. It also comes up sometimes as a basis for a non-infringement position. So when it comes up in this context, the term might be subject to the requirements of 112F and the structure disclosed in the patent, which would govern the scope of the term, differs from the accused device, so that if it is interpreted as a means plus function term, you would have no infringement. One additional point I wanted to make in terms of significance during litigation that's not on the slide relates to IPRs, inter-parties review proceedings, and means plus function interpretation can be relevant and potentially very important during IPR proceedings because the PTAB will at times decline to institute an IPR if it turns out that the term should be a means plus function term and either the petitioner failed to properly address the correct structure. So, either thought it was a different structure than the patent owner identified or simply didn't address it as a means plus function term at all. Or the PTAB will sometimes decline to institute IPR if it determines that a term is a means plus function term that lacks the adequate structural disclosure and therefore is indefinite and impossible to analyze under 102 or 103. So a few practice tips for using processor claims, because it is very common to use processor in claiming. One thing I would say in terms of whether to use processor or a different word, use processor if it's unquestionable that the function that is being performed will be implemented in a processor, or if it, in other words, if it cannot be implemented on something else. But if other structures can be used, such as an ASIC or an FPGA or other structures that are technically not, may not be considered a processor, consider something a little bit different like circuit or control circuit. And there is, valid law, and again, it's context specific, but there are multiple decisions in the US that interpret the term circuit, especially with a descriptor like control circuit, as not being means plus function terms, and having a sufficiently definite structure understood just by the term itself. So Massachusetts Institute of Technology, that case, is a little bit old, but it is still good and it is still cited for this proposition. You can use method claims as well, and they will offer some broader coverage. So if you want to describe the method rather than limiting it to a processor or using something like circuit, the one thing to keep in mind when using method claims for this type of or claiming in this way is it's going to be enforceable on an end user rather than a manufacturer, or through indirect infringement claims against the manufacturer. And those are a little bit more difficult than just the pure direct infringement claim based on an apparatus. And so sometimes you'll have both. You may have both a claim that recites a circuit or a processor, and then also other independent claims that are method claims. Because 112F is so context specific, when you use processor in your claims, you just want to ensure that the claim is drafted in a way that shows a sufficient structure that processor wouldn't trigger 112F if that's what you want. So processor configured to and reciting a specific function might be a little dangerous, but something like at least one processor and then a whole separate clause, at least one storage medium having encoded thereon executable instructions with some more specifics is probably a safer way to go about the claim drafting. And I'll address these quickly as I'm just about out of time. If you receive an office action during US prosecution where a term is treated as a means plus function term, you have a few options. The first thing you can do if you disagree is you can respond with arguments that would show that either the existing claim language or the specification itself provides a sufficient structure for the term. You can cite, again, to dependent claims, surrounding claim language in the contested claim, specification, etc. You could simply amend the claim to change it so that if it didn't have a definite structure as it was written, you can add that to resolve the examiner's interpretation and have the examiner reconsider whether it should be subject to 112F treatment. Or if the 112 interpretation, if the means plus function interpretation really isn't relevant to issuance, you can simply note the disagreement. You can file a response that notes that you disagree with the examiner's interpretation, but say that it's not necessary to resolve the issue because, and then explain why it's not relevant. You typically would still want to identify the corresponding structure, especially if the examiner has identified it and you disagree with it, because regardless of what happens during prosecution, you could still dispute this during litigation, but it will be easier and more likely to succeed during litigation if you make some statements during prosecution history that would support positions you may take later. If you stay silent, then it's a bit more difficult to win on the arguments during litigation. So that's all I have for tonight and this morning. Thank you very much for your time.
Thank you, Libby. Does anyone have any questions for Libby? I think there's one in the chat box, Libby, about in the SAGE case, what is an example falling in this category? That was a little while ago.
I can't see the chat box in my view, but let me just go back and look at the SAGE case quickly. So the SAGE products cases, it has a great definition of that rule, but it's actually not a great case itself for what's stated here, in that SAGE was a little bit unique in finding a means plus function term, a term that used means as actually not being a means plus function term. But I think a good example of that is actually the Samsung case, where digital processing unit on its own, if you just looked at that term and the function, it seemed like a means plus function term, and that's how the PTAB interpreted it. But if you actually looked a little bit further at the language that followed in the claim, as well as some of the dependent claims, there was enough structure that someone who practiced in the field would see digital processing unit and actually understand some structure associated with it.
Thank you. We have a question from Kinoshita-san. In relation to slide 15, what is an expected outcome if we recite a processor, but not a relating component, such as a medium or a memory?
I think I would probably have to see more claim language to answer that question well. I think, and it may depend honestly on the specification as well. So that's probably not a very useful answer.
But it's a common answer for lawyers.
Yeah, I know.
We have another question from Izuka-san. I think a lot of applications originating from foreign applications incorporate claims not preferable in terms of 112F. When do you think it is best timing to amend and adjust claims to the more preferable format to avoid 112F issues? Also, which should we file, a preliminary amendment or CIP when amending?
So I would say it's preferable to amend it, to make that change as early as possible, so that, for instance, you know, if you get an allowance without any office actions and then it's overlooked and it eventually were to come up during litigation and no one had given any thought to it, but it is still susceptible to either invalidity or defenses based on means plus function, that's something that can happen, especially when an application is based on a foreign patent or patent application. Whether to do it as a preliminary amendment or a CIP probably depends, again, on the context and the priority chain and, you know, what you're going for. But I would, in general, I would say you want to make that, you want to be looking for that early on in the process of filing a US patent application.
Thank you. Konishi-sensei, did you have a question that you wanted to ask?
Yes, thank you. Could you hear me?
Yes.
Yes, we can hear you.
Thank you. Thank you, Libby, for your clear-cut presentation. My question is concerning the intended use limitation. We see in some cases, prosecution cases, functional terms in claim is also construed as intended use, and then simply ignored in construing claims. So I appreciate if you can give us, Japanese practitioners, some suggestion in order to avoid such limitation. Thank you.
Sure. Do you mean where the language is something that's meant to be limiting, but the examiner says, in fact,
yeah,
this language doesn't limit, it's merely a statement of intended use?
For apparatus, even for mechanical or electrical cases, we often see such, you know, simply ignoring.
So
it's pity for us.
Yeah, it typically comes down to to the claim structure. And so, I mean, I see these issues come up a lot when you have something recited in the preamble only, and then it never actually makes an appearance in the body of a claim. And so it turns out what you thought was a limitation was really a statement of how or where or when you might use this device, but there's no sufficient limitation in the body for that purpose. And so, I mean, I think it depends on what you're trying to do.
Yeah, well, we see many cases where even we put some limitation in the body of claims, still, you know, the intended use interpretation arises.
Yeah, you want to have language that makes it clear that it's something that the device or the element does, not something that it merely can do. And that can be a problem when you use configured for language. Sometimes that comes up when there are disputes, you know, just because something is configured to do something doesn't necessarily mean it actually does do it. And so I think the more precise your language can be and the more discrete limitations you have rather than just sort of long descriptive limitations is probably the best way to accomplish that. But it is very context specific, so I don't know if I can give sort of a guaranteed winning approach for each, you know, any claim that would apply.
Thank you for your suggestion.
Okay, I think we have time for one more question. We have a question from Okato-san. When the examiner checks the specification, if there is not enough structure, does it cause a 112A or 112B rejection?
So I actually don't know for sure what the rejection would be under, but it would be under 112. It would probably, I mean, it may be an indefiniteness rejection because if it doesn't have sufficient structure, if it has already been determined to be a means plus function term and it doesn't have a sufficient structure, then it would get a rejection for indefiniteness. But off the top of my head, I can't remember which letter that is.
Great, thank you. Any other questions that people want to ask Libby? Thank you very much for that presentation. So our next program is a very special one and different from the format of our past meetings. We're very excited to have a panel discussion regarding trade secrets featuring panelists from all three of the participating organizations today. I'll turn things over to Mr. James Abe to introduce the panel. James.
Thank you, Jason. Hi, everyone. Good afternoon to those in the US and ohayou gozaimasu to those in Japan. My name is James Abe. I'm a partner of the law firm Wolfson & Bird. I'm in the IP litigation group. I handle all sorts of mainly patent litigation, trade secret, technology-based litigation. And one thing I noticed over the past couple of years is that there's much more increasing interest in trade secret issues, and you see a lot of more bigger cases, lots of activities, new laws being enacted, and amendments to prior laws, et cetera, et cetera. And I think this is a very timely topic to have this panel discuss, and I will introduce our esteemed panelists for today. First, let me introduce Ms. Kei Konishi. Konishi Sensei is the Vice President of the JPAA and is founder and managing partner of Konishi and Nagaoka IP firm. She's been practicing as a Japanese patent attorney for over 20 years, and prior to becoming a patent attorney, she worked as a system engineer at IBM Japan, and also lived in Italy as part of that job, which I found very interesting. She works in all aspects of patent matters, including patent prosecution, translation, infringement litigation, among other IP-related areas. And next, I'd like to introduce Mr. Miki Goto. Goto Sensei is a partner of the Anderson, Mori, and Tomotsune law firm. He is an attorney at law, also has an academic background in both science and engineering. And he also has experience working in the IP department of a major electronics company. Goto Sensei's practice covers a wide range of IP matters, including disputes concerning patents, trade secrets, trademarks, among other areas. And he serves as vice chair of the Standing Committee on Trade Secrets for AIPPI-Japan. And last but not least, we have Mr. Jim Pooley. Jim is a Silicon Valley lawyer representing clients in trade secret and technology-related commercial disputes. He advises companies on IP strategy and data asset management, and also serves as a special master, expert, and arbitrator. Jim has authored several major treatises, including a well-known treatise on this very topic, trade secrets. And in fact, during the consideration of the DTSA, that's the Defend Trade Secret Act, the Senate Judiciary Committee relied on Jim's expert testimony. Jim also served a 5-year term as Deputy Director General at WIPO in Geneva, and is also past president of the AIPLA. I'm very honored to join this esteemed panelists to talk about trade secret issues today. Now, why don't we kick off this discussion with a very high-level overview of trade secret law, in case some of you do not practice trade secret day-to-day. Miki, would you like to give a high-level overview of Japanese perspective on trade secret law?
Sure. Hi everyone, I'm Miki. So I'm sharing slides to quickly overview framework to protect trade secrets in Japan. So those are all very familiar for some of you, but yeah, just for warming up purposes, I will introduce the basic framework. So in Japan, trade secrets are protected under the law of Unfair Competition Prevention Act. So the law provides the definition of trade secret and provides for certain misappropriations, such as acquiring trade secrets by theft, as illegal unfair competitions. And if you as a holder of trade secrets and keeping your trade secret as secrets, and someone misappropriates your trade secret, you may seek for civil actions, such as injunctions and damage at courts. And you may go to a prosecution office or the police to ask them to initiate criminal action as well. This is a statistical trend for trade secret cases at policies. So you may see that we have a steady increase of cases investigated by the police in recent years. And finally, I would like to overview the key requirements for your information to be qualified as trade secret. So there are 3 requirements, and I think those are similar to those you have in the US under the international treaty regime. So first one is that your information needs to be not publicly known. And the second one is that your information needs to be commercially useful. And finally, the third one, which is the most important in practice, is that you need to manage your information as secret. This means that you need to take reasonable measures to keep your information as secret according to the relevant circumstances in a ways that your intention to keep the information secret can be objectively recognized by others, such as your employees and outsiders. Okay, those are the basic framework from Japanese side.
Thank you, Miki. Now let's turn over to the US side. Jim, would you please give an overview of the US side?
Yes, thank you, James. And the basic three elements that were just described are the same under US law, but we got there in a different way. Trade secrets developed in the US not from statutes, but from common law. It developed from courts deciding cases where one party had entrusted another party with their information, and then there was a breakdown in the relationship. So trade secret law in the US, borrowed from Great Britain at the beginning of the 19th century, has always focused on principles of ethics and fair business behavior. And those ideas animate the interpretation of the statutes that we have created in the 20th century. The Uniform Trade Secrets Act, which tried to harmonize laws among the states, and then more recently, the Defend Trade Secrets Act of 2016, which has created a civil claim at the federal level. The standards that are applied in all of these statutes are the same as those described in Article 39 of the TRIPS Agreement of 1995. And that agreement was patterned on the Uniform Trade Secrets Act. Finally, it bears mention that in the US, because of the Defend Trade Secrets Act, now many more cases are decided at the federal level rather than at the state level. That, in a way, makes trade secret cases more predictable than they have been before because the law is now more harmonized. And a little bit later, we'll get into talking about a couple of the effects of that federal application of trade secret law.
Thank you, Jim. Now that we have a sense of some of the similarities in the basic framework of both countries, why don't we jump into some of the trends, recent developments that are of interest. So, Kay, let's turn to you for a second. So I understand there's been some recent changes to trade secret law in Japan. Can you please explain why that change happened and give us an overview of what specifically has changed?
Hi, hello, friends. Let me start with Nippon Steel versus POSCO case. This is it, which is a landmark case in Japan, including large-scale misappropriation of trade secret beyond border. Nippon Steel, previously Nippon Steel and Sumitomo Metal, is a top-tier steel company in Japan, and POSCO is also a top-tier steel company in Korea. So both companies are obviously competitors in steel industries. This is a long history started in 1968. Over 20 years, ex-employees of Nippon Steel who were seduced by and in conspiracy with POSCO have unlawfully acquired trade secret concerning manufacturing process of oriented magnetic steel sheet and disclosed it to POSCO. Using the trade secret, POSCO has boosted its market share of similar product. The trade secret used by POSCO was then sold to and used by Baoshan Steel in China. This misappropriation was revealed in criminal action in Korea, framed by POSCO against Baoshan Steel, where ex-employees of POSCO testified that misappropriated information from POSCO was originally stolen from Nippon Steel. Knowing such facts, in 2012, Nippon Steel filed a civil action against POSCO in Japan, claiming damage of 100 billion Japanese yen. And eventually, Nippon Steel and POSCO settled, with POSCO paying 30 billion Japanese yen to Nippon Steel, which is approximately 0.3 billion US dollars, so far second highest in Japan in terms of the settlement amount. Nippon Steel was very smart because prior to filing the civil action in Japan, Nippon Steel obtained the court decision in Korea and collected and preserved necessary evidences in advance to filing a civil action in Japan. As you may know, Japan has no comprehensive discovery system, unlike US. So it may be a good strategy for collecting evidences in Japan. This Nippon Steel case triggered the latest 2015 amendment to UCPA, Unfair Competition Prevention Act, significantly enhancing trade secret protection. Nippon Steel was one of the strong lobbyists. Notably, this amendment was based on common understanding that the majority of large-scale trade secret misappropriation is not made by outside espionage, but rather made by insiders with malicious intent, seduced by overseas companies. The most significant part of the amendment is enhanced criminal penalties comparable to other jurisdictions to newly punish subsequent acquirers, overseas acquisition, and attempted crimes, and also to punish and also to confiscate criminal proceeds and to fine heavier against overseas crimes. And extraterritorial application of UCPA has been also enhanced. For example, in Nippon Steel case, prior to the amendment, Baoshan Steel in China was not subject to a criminal charge because it did not directly acquire the trade secret from ex-employees of Nippon Steel, but the amendment it is. Companies abroad knowingly acquiring, disclosing, or using the trade secret within a chain of misappropriation are all subject to the criminal charge, even if those acts happen abroad, as long as the trade secret is owned and controlled in Japan. Acquisition abroad, like from a server abroad, is newly made criminally chargeable. In terms of civil remedies, the amendment shifts the burden of proof from trade secret holder to accused infringer in case of the trade secret concerning production know-how. That means the accused infringer needs to prove that the accused product is made without using the trade secret at issue. Seizures at customs is also newly made available. The last slide. Okay, remedies and penalties are quite powerful now in Japan, but unless your confidential information is kept secret, which is comparable to reasonable measure requirement in states, those remedies are meaningless. The kept secret requirement is critical for seeking for protection of trade secret. We used to have quite high standard, strict standard, so keeping information secret was headache for companies. But no more. In this decade, Since around 2010, kept secret requirement has been relaxed in courts. In Japan, the administrative authority, METI, is quite active to give non-binding guidelines, very Japanese. Since 2016, we have two-tier protocols. Second tier, 2016 METI handbook is no surprise. It shows recommendable best practice for preventing leakage of trade secret. More notably, first tier is revised trade secret management guidelines. Significance of this guideline is having a realistic view. It shows a reduced and minimum standard dedicated for kept secret requirement only, which are assumed to be feasible even for small and mid-sized companies. Under the guideline, the test for kept secret is whether a trade secret holder's intent to keep it secret is objectively recognizable by employees or competitors through measures to keep it secret, reasonable measures. Reasonable measure is now easier. Access restriction is no more mandatory to prove measures to keep it secret, depending on circumstances such as size of companies. That means that the access restriction using password is not mandatory if the size of company is small. Likewise, access restriction having an NDA, non-disclosure agreement, is not mandatory as well. Of course, those guidelines are no more than administrative ones and subject to the judicial review. Nevertheless, it is assumed to function as a clear guidance which companies should follow. Thank you.
Thank you. So we heard some interesting stories about some of the guidelines in terms of reasonable protection, reasonable measures, and penalties against the acquirer, not just the person that actually does the misappropriation, but the person who receives it, having liability there too. Jim, why don't we focus on you for a second? So maybe provide some updates on what's going on in the U.S. What are some of the hot topic issues, and maybe also touch on some of the any tips you have on terms of the reasonable measures. Certainly, I'm not aware of any two-level standard in the U.S., but I thought that was very interesting in Japan. But why don't we start with what are some of the hot topic issues right now?
Yes, well, I mean, just commenting on reasonable efforts for a moment. In the US, I think something similar has happened as what I've just heard about Japan, in the sense that we expect companies to act in the context of the threat environment that they face with their information. In other words, there is no one size fits all for reasonable efforts. Whether something is sufficient or not necessary at all will depend on the circumstances and the risk that the company faces to its information. Trade secrets have become an area of focus all throughout the world. And just as in Japan and the US, we have been looking at trade secrets. And of course, as I already mentioned, our most recent dramatic change came 4 years ago with the Defend Trade Secrets Act. One of the biggest issues that was not clear at the time was whether or not that statute would be applied by US courts to misappropriation of trade secrets that happened in other countries. So this has become the issue known as extraterritoriality, a very long word that describes the issue of whether or not US courts can exercise jurisdiction over a case where the wrong acts, the bad acts happened in another country. We got an answer to this finally, a very good, thorough answer in a case that was decided in January of this year, Motorola versus Hytera, where the misappropriation happened in Malaysia, and the information was transferred there. It was used by Hytera to create products that used the technology, and then those products were sold in the US. And what the court decided was that the DTSA did allow jurisdiction over that theft of trade secrets in Malaysia because of the actions of selling in the US. The DTSA contains a provision that says that the act will apply to any misappropriation where any act in furtherance of the offense happens in the US. And here the court said that using the information to sell products in the US satisfied the statute. And that led to a jury verdict of $760 million, or about 800 billion Japanese yen. So one of the most important things that's happening in the US right now is that we are taking the litigants here in the companies that have these cases, are taking them to federal court and not state court. State courts would be very hesitant to exercise jurisdiction over foreign acts, but federal courts are quite willing to do that. And what that means is that cases that arise in countries outside the US, but that affect the US market, can be pursued in federal court here. And the damages that we've seen in recent cases are sometimes very much like this, in the hundreds of millions of dollars. So that has been one big development in the last few years. Along with that is enforcement of trade secret rights in the International Trade Commission, which has been around for decades and decades, but typically handled patent cases and only rarely dealt with trade secrets. But since a case that was decided in 2011 called Chanrei, that case emphasized that the court had jurisdiction over the importation of goods into the US that had been tainted by, affected by the misappropriation of trade secrets in a foreign jurisdiction. And the ITC, the International Trade Commission, is a very quick remedy for getting injunctions, what we call exclusion orders. And although it acts only against the products, what we refer to as in rem jurisdiction, and not directly against the owner of the goods that are being brought into the country, in effect, it forces the respondent, it forces US style discovery. And so, as you know, in trade secret cases, finding out what happened can be a very difficult part of the task. And so in the ITC, companies can assert trade secret rights and get access to discovery from the foreign defendants. And this is even true of foreign companies that have operations in the US where they have created a more or less domestic market, as we've seen with the case between the LG Chem and SK Innovations, both Korean companies, and the two of those companies were fighting in the ITC because each had operations in the US that allowed the ITC to have jurisdiction. So the big news in the US these days is the ability of US courts and the ITC to reach outside the boundaries of the United States and take jurisdiction over cases that started in another country.
Thank you. You know, it's very interesting how the courts are finding ways to have more extraterritorial application. That is a long word, isn't it?
It is.
Certainly. And certainly what you mentioned about the difficulty of finding infringement is always a challenge. So certainly having the option of discovery is always a strategic consideration. Again, it's not every day that the misappropriator files a case in another jurisdiction and their own witness testifies that that they had misappropriated trade secrets. So,
yep.
Well, why don't we shift gears a little bit? And this year has been, you know, a very crazy year, the COVID-19 pandemic and whatnot. So why don't we talk about that for a little bit? The pandemic was very disruptive, obviously, and companies were trying to adapt on the fly very quickly. And, you know, during these stressful times, I think it's a good way to see, you know, what our company is doing, kind of confirm good practices, and also as this, you know, may continue for long term, what are some of the good practices that companies should start doing in terms of making sure their trade secrets are protected. And Jim, why don't we stay with you for the U.S. perspective? What have you seen?
Yeah, sure, James. I think, well, it's been a massive challenge to U.S. industry. And what it highlights is the paradox of managing trade secret assets. And by that, I mean, in order for something to qualify as a trade secret, we have to keep it a secret. But in modern commerce, in order to extract value, we have to share the secret. We have to share it with companies that are part of the supply chain. We have to share it with customers and vendors. We have to share it with employees, sometimes tens of thousands of employees who have access to all of the company's valuable information on their smartphones. And so trying to figure out how to do this when all of the people who have to have access to the information are now scattered. They're no longer coming to the office, right? Companies used to have to take care of executives who would be traveling to meetings, and how do they keep the information safe? How do they provide secure access to the company's data? And now this problem has all of a sudden atomized with over tens of thousands or sometimes hundreds of thousands of employees who are working from home. So this, to begin with, had a huge impact on the IT departments of companies because of the infrastructure. They had to set up the VPN systems that they needed to provide to employees, the access controls that they needed to make work for this particular environment, and then the training of employees and assessing risk in this environment becomes much more difficult because the employees are not in the office. You're not watching what they're doing. You're not managing them directly. It's at a distance. Other people are in their homes, wandering around as they're working with confidential information of the company or its customers. And so this environment has become a big challenge, and companies are having to rethink how do they limit access, what kind of information do they provide to certain employees and to certain customers, because they know that when they give that information to their customers, it will go to the customer's employees who are at their homes and not at the office. So the entire risk environment has changed, and companies have had to reconfigure their management systems to adapt to this.
Thank you, Jim. Let's hear from Nikki. Nikki, how has the pandemic affected trade secret practices in Japan? What are companies doing to protect their trade secrets?
Yeah, I think this is very challenging and interesting for Japanese companies as well. And my personal impression, speaking with my clients and friends in companies, Japanese companies, is that Japanese companies tend to be more conservative to allow their employees to access their important trade secrets from home or outside of offices in general. But still, I think with this difficult situation of pandemic, companies still need to rethink about how they take appropriate measures to protect their trade secrets when they allow employees to use, access, share, copy the company's trade secrets in a variety of situations. So let me just recall the three requirements for in Japan to protect their information as trade secrets. So I think in relation to the requirement number 1 and 3, I think the companies will need to rethink about how they can meet those requirements in the situation where their employees would access trade secrets in more variety of situations. So for example, when their employees will bring their confidential documents back to home from outside of offices, there would be the new risk, more risk that those confidential documents could be divulged to intentionally divulged to outsiders. And also, as I mentioned, in relation to the requirement number 3, the company's measures need to be objective in a way that the company's intention to protect the secrecy should be objectively recognized. So when companies allow their employees to access their information outside of offices, what would be the objective measures? That would be a challenging question, I think. And for your information, actually, during the emergency declaration situation in May this year, the Japanese government kindly published a Q&A paper discussing how you could better protect your trade secret in remote working environment. So it may be worth taking a look at those Q&A.
Thank you, Nikki. It's very interesting that government seems to have some sort of manual or guideline every time there is a challenging question. And certainly what is a reasonable measure and what's reasonable protection is a challenging question. And you heard from Jim earlier, the great point about there's no one size fits all. And I think that seems to apply for both countries. You know, a small company cannot have the same level of measures just practically as a big company with many people working in IT and legal and IT, et cetera. So maybe Jim, maybe back to you for a brief moment. Do you think in terms of that flexible, if you will, standard of what's reasonable, would pandemic and those considerations, would those issues be taken into consideration as well?
Oh, absolutely. I mean, one of the principles that we recognize, and I know something about this because I spend some of my time as an expert testifying about reasonable efforts. And one of the principles that guides decision-making here is that the threat environment is dynamic. And so the things that you need to do to take adequate care of your information assets will change with the circumstances. And this can just change because your business model has changed, the customers that you do business with or your supply chain has changed, and it can result from changes like the pandemic and the different working environment that you face. So as we address issues of information security, we always look at what is the current environment, what are the risks that we're facing now, how are they different than before, what do we need to do now that we didn't need to do before, right? So it's all very much a matter of context.
Right, thank you. Kate, do you have any comments on this topic?
Thank you. Just one comment. Under the current COVID situation, remote working, teleworking is prevailing. So technical measure matters more than ever because of teleworking. The confidential information has become more paperless and digital transformation is demanded. In order to maintain kept secret requirement, many kinds of technical measures we need to rely on. That includes, for example, the security measures, which allows remote access to the confidential information through VPN without transfer, copying, or printing of electronic files through encrypted network. That's one example that what we need to rely on. Thank you.
Thank you. I have a question. Why don't we, can the panelists see the question?
Yes, I can see it.
Okay, so I'll read it out for those. Maybe we'll take a question right here. Japan has recently introduced new protection system, so-called shared data with limited access, Gente Teikyo Data system into the Unfair Competition Prevention Act in July 2019. This can be viewed as a sort of semi-quasi-trade secret. I'm not sure if such is known to US practitioners, but I understand there is not so much impact on international practice for now. And what is your opinion on this new system? And there's a link to a METI website. Anybody care to take this question on?
I would wait for one of my Japanese colleagues here to comment on this specific one, but I can comment on comparable distinctions that are sometimes made in the U.S. You know, we sometimes in some jurisdictions and some courts, you'll see a distinction made between confidential information, in quotes, and trade secrets. And the suggestion is that confidential information deserves some protection, but not as much as trade secrets. This is an old and kind of outmoded way of thinking that results from the way in which we viewed trade secrets in the early part of the 20th century, was that they had to meet a very high threshold. The modern formulation for trade secrets reflected in the Uniform Trade Secrets Act and the DTSA has a very, very low threshold. As long as information is not generally known and has some modest, almost trivial value, then it can qualify as a secret. And so these old distinctions between confidential information and trade secret are really not that meaningful. In businesses, of course, some trade secrets are much more valuable than others. And so we tend to call those with a phrase, the crown jewels, the most important jewels that belong to the company. And so we pay more attention to those data assets than we do to others. But everything, all of those data assets are treated by the law as trade secrets.
Thank you, Jim. Well, if others have anything you want to comment on, maybe we continue on. I see a couple more questions. Maybe we'll get to the next segment. Before this question, we were talking a little bit about the good practices and what measures to take in light of the pandemic. And there's one thing I wanted to touch on that before we go on to a different topic for a little bit. And that is, having NDAs in place is usually a big issue that's looked at court and litigation. So, Kay, one question for you. Traditionally, I feel like for Japanese companies, there's a tendency to not rely on written contracts, at least compared to U.S. companies. What is your view in terms of the NDAs? Are they important? What are some of the tips you have for having a proper NDA in place or not?
Thank you. Let me. Yes, even though the NDAs are not mandatory under the guideline, still NDAs are 100% important. It is reported that about 60% of misappropriation of trade secret is made by employees or ex-employees. I think similar in US. This is why drafting NDAs is critical, and many Japanese companies are well aware of the importance of NDAs these days. Here's do's and don'ts in drafting NDAs. Don't assume that the trade secret never leaks. That's a fantasy. Instead, it should be assumed that the trade secret 100% leaks. So we need to draft concrete clauses on penalties when leaked. Don't build up overly complex routine in order to keep it secret. Such complex routine, don't ask about to leave employees to sign NDA. That's too late. He may refuse. No, I won't. So ask him earlier when employing or when starting project. When drafting NDA with competitors, minimize the scope of disclosure and third parties to be subsequently disclosed. NDA is not almighty. Minimize your risk. Restrict unintended use of trade secret, which is helpful to prevent competitors from using your confidential information for creating improvement or derivatives without your knowing. If you are receiving party of trade secret, separate your own creation from originally disclosed confidential information by opposing party. Avoid contamination of disclosed confidential information into your own creation. Lastly, consider to complement statutory trade secret under UCPA for enhanced protection of would-be trade secret under contractual agreement. We can define the broader scope of contractual confidential information, whatever you like, than statutory trade secret, which may facilitate enforcement under contract law. Thank you, that's it.
Thank you. Yeah, I think I certainly agree with that. Those practices, that very important to have proper agreements in place. Certainly true in the U.S. too. Unless Jim and Mickey, you want to add anything on best practices and NDA practices, maybe we move on to enforcement. As I see there's a question about that. Maybe it's a good segue for that. So the question we have is from JDP. I'd like to ask a panel question about criminal actions to enforce trade secrets. Would you like to, not sure who JDP is, but ask the question to the panel?
Sure, this is John Pegram. And my question is about the use of the police and the use of criminal enforcement activity, both in the US and Japan. How do the panelists feel about that? Do they think it's very effective? The reason that I am asking is that we've had some really bad experiences in my career where things were turned over to a government agency to try and enforce trade secret rights. And basically they didn't invest the amount of effort and time to properly handle it. So I'd be interested in what the panelists would think about the government enforcement of trade secret rights.
Jim or Mickey, would you like to
Okay.
take a shot at the question?
So in Japan, I think traditionally, unfortunately, if you don't have sufficient evidence to show that your trade secret has been infringed, I think the police or prosecution office might not take it serious, and they wouldn't work hard to collect evidence on behalf of you. On the other hand, if you have sufficient evidence, including the civil court's order, the police or prosecution office would take it serious. That's a traditional attitude of the police or prosecution office. And maybe with the change of the government attitude in general, you may have more chances to go with the criminal actions, consulting with the police or prosecution office. But I would still recommend that you would have sufficient or at least reasonable evidence to show that your trade secret has been infringed before going to the police or prosecution office. Or the strategy would be that you go to the civil courts in parallel to have the civil court's orders, and you may use the procedures to seek for criminal actions at police or prosecution office as well. That's my general view.
Thank you, Mickey. Any other comments for the panelists? Why don't we stay on this enforcement issue and talk about a topic of that's come up a couple times already about the challenges of proving misappropriation litigation. Mickey, maybe we stay with you for a second. Without discovery in Japanese litigation, is there any presumption or something that can lower the burden of proof on the plaintiff? Any ways to get evidence in the Japanese legal system to show misappropriation?
Yes, let me share slides. So yeah, the burden to prove infringement is on the plaintiff side. So it's and without a general broad discovery in Japan, it's always a challenge for the plaintiff, the right holder, to prove misappropriation by the accused defendant. And kindly, maybe not so useful, but the Japanese law provides for a few mechanisms to help the plaintiff to prove misappropriation. I list the three of those measurements. And one is that the presumption of misuse for trade secrets relating to manufacturing methods. So if the plaintiff proves that your trade secret has been illegally obtained by the accused defendant, accused infringer, and the accused infringer has conducted a manufacturing of certain items which can be obtained using your trade secret, it is presumed that the accused infringer used your trade secret. That is one measurement to help you prove infringement. And maybe before going to the other tools, I pass to the Jim to have a comment from the US side.
Sure, that'd be great.
Okay, yes, I think certainly for US companies, if the action can be enforced in the US, that's preferred precisely because we have a discovery system that allows us, based only on reasonable suspicion about what happened, to get access to all of the evidence that the defendant has. And it's this, this difference in access to proof that I think drives a lot of companies to prefer trying to get actions in the US or perhaps in countries that have a common law system like Canada and the UK or Australia. But it's quite helpful. And certainly this is the direction I think a lot of civil law jurisdictions are taking. It's very helpful to have this kind of burden shifting that you've just described in the Japanese law, because it helps to ensure that a trade secret owner that has a pretty good idea what has happened and has some evidence to help to prove it can at least open the courthouse doors and get the action started, and hope perhaps to shift the burden to the defendant to show that, or to try to show that they engaged in independent development, that is, development independent of the information. This is never going to be perfect because there is a judgment call made by courts on what is the amount of information that's necessary in order to invoke this shift in the burden of proof. And from one case to another, it may not be predictable for the trade secret owner what it is that will be necessary to get the benefit of it. And in any event, most trade secret owners would rather be assured that they can get full access to all of the evidence of what the defendant did. So that's a basic difference. It's not the only issue that U.S. companies consider when they're dealing with cross-border misappropriation issues, but it's quite an important one.
Thank you, Jim. I know we're almost out of time, and I apologize. I had missed that there were several more questions that came in. If time permits, I know Okuyama Sensei had a comment. So if we still have time, maybe we could hear from Shoichi Okuyama Sensei briefly.
Okay, well, thank you very much. Do you hear me?
Yes, we can hear you.
Okay, very good. Well, going back a little bit, the restrictively provided data, this is very difficult term to translate. This was a very interesting attempt by the Japanese government to protect data, which is basically publicly available under the scheme of unfair competition. But there are two problems actually, which became very clear immediately. Is that the data that they are talking about is something like data printed on paper. In the reality, however the data is provided, they will get mixed up with other data and used as a big data for AI and other applications. And you don't know which data is which. And the second problem is the international cross-border issue in this current cloud environment. Well, the protection in Japan is not really sufficient. So although the attempt was very interesting and very first in the world, I would say, but I don't think that this new scheme will work. And the second point is the government enforcement, the criminal enforcement. Well, we discussed the evidence collection is difficult in Japan. And so criminal enforcement has a very strong measures for evidence collection and used quite a bit. You know, the Mickey showed us increasing number of criminal cases. And some cases are good, I'd say. There are valid reasons for well, trade secret protection, but some cases, as I see it, is abuse of the system because internal power fight element comes into the trade secret protection, and well, but the government is taking on those cases, and I don't like that. I mean, you know, I don't think that's a very good way of using the trade secret protection system. Well, thank you.
Thank you, Okinawa-sensei, for sharing your insights. Well, unfortunately, I believe we're out of time. There are many more great questions that I apologize. I could not have the panelists answer in the time we were allotted, but you know, I'm sure everyone would be happy to answer questions. Maybe reach out to them by email, and I think you could find their contact. I certainly had an easy time finding their contact. They're very famous and everywhere, so please contact them if you have questions on them. So with that, why don't we give our panelists a great round of applause for answering all these tough questions and very good questions as well. So I don't know if there's a clap button on this, but it's from me.
Thank you.
And
thank you very much.
With that, we will conclude the panel discussion on trade secrets.
Thank you, James. Thank you to all of our panelists. This was a great program. I hope everybody enjoyed the first panel that we put on as a collaborative effort between all three of our organizations. And I also want to thank all of our speakers for their interesting presentations and everyone's thoughtful questions and answers. I certainly hope that everyone found the information that was discussed today as useful as I did. So before getting to the closing remarks, I would also like to extend our thanks to Honda Hirokazu sensei and Sakashita Noriko sensei for their leadership and efforts in organizing this joint meeting. I'd also like to recognize Sharon Israel, who has been, again, hosting this meeting on Zoom. So thank you very much for ensuring everything has been running smooth today. So to conclude the formal portion of today's program, I would like to invite each of the organizations to provide closing remarks. So first, I would like to invite the first Vice President of AIPPI, Mr. Shoichi Okuyama, to offer closing remarks.
Okay, well, thank you very much. We are looking forward to seeing each other on December 1st, and I don't know if my remarks are useful, in this very short time intervals. But anyway, I mean, this was great meeting, and well, there is the breakout sessions afterwards. And as a vice president of the AIPPI, I would very much like to thank those people who participate the World AIPPI World Congress online that took place last month. And that was great success. We had the 1,800 participants, and we really appreciate your cooperation and attendance. Thank you very much.
Thank you, Okuyama Sensei. I would now like to invite Mr. Shinichi Watanabe, Director General of the International Activity Center, to offer closing remarks on behalf of JPAA.
Hello, everyone. I'm Shinichi Watanabe of JPAA International Activities Center. First, I'd like to thank the members of the AIPLA IP Practice in Japan Committee for hosting this Zoom meeting today. It's wonderful that this technology enables us to see one another and share information among 3 organizations while working remotely or from our workplaces in different countries. I'd like to thank all other speakers for the enlightening presentations and discussions. As always, we learned a lot. As you know, our next Zoom meeting will be held on November 30th in the United States and Canada, and it's December 1st here in Japan. I'm looking forward to seeing you all again in 3 weeks. So, see you soon. Thank you.
Thank you, Watanabe Sensei. I would now like to invite Mr. Brian Batsley, first Vice President of AIPLA, to offer closing remarks.
Thank you, Jason. And thank you for the closing remarks from Okuyama-san, the first Vice President for AIPPI, and Watanabe-san, Director General of the JIAC. Very well said, and I feel the same way. As Mr. Murata said at the start of the meeting, it's unfortunate that we could not have our annual pre-meeting before AIPLA's annual meeting, but I'm thankful that our exchanges and meetings, both educational and networking, are able to be continued. I hope we can continue conducting these meetings virtually until we are able to meet again in person, which on a personal note, I hope is very soon. On behalf of AIPLA and IP in Japan Committee, thank you for the presenters and the panel. It was a very interesting presentation, very helpful and valuable. The meeting sponsors, all the members of JPAA and AIPPI-Japan, and leadership and organizers of AIPLA's IP in Japan Committee. And finally, Shimizu-san, President of JPAA, for his opening remarks. I hope everyone is safe and well, and I look forward to our next meeting.
Thank you, Brian. And thank you, everybody, for attending. Just as people have mentioned already, our next program will be in 3 weeks. I hope everyone can join. This concludes the formal portion of today's program. The recording will now conclude.